In order to form a more perfect union and establish justice, the Constitution of the United States was established. From the Constitution flows the law of the land. But sometimes we come up against the law and just don't know what to do. I'm Sidel Pitas, and from time to time we talk about what happens when you come up against the law and how it affects us all. Today we're going to talk about coming up against the law of trademarks. Although I am a lawyer, what you hear today is not legal advice. For legal advice, you have to go with your specific facts to your own lawyer. With me today are two very talented performers, Carolyn Najarian and Glenn Doyle, and they are going to help us show how trademark law affects us in real life. And also with me today is our legal assistant, Suzanne Koenig, and she's going to assist us by asking some of the questions that may be on your mind.
Why don't you start out today by telling us just what a trademark is?
All right, I will. A trademark is something that distinguishes the goods of one person from the goods of another. Or there can be a service mark that distinguishes the services of one party from the services of another. Now, those kinds of trademarks and service marks are property, but they are intangible property. They're products of the mind, called intellectual property. And other kinds of intellectual property are patents, copyrights, trade secrets, and maybe on some other programs we'll talk about those. Now, in medieval times, trademark was a mark that was placed on the bottom of an object by a trade or a guild to show the source of the object. And in the United States, in the 20s and 30s, according to the authors of this book, trademarks captured the social speed at which a graphic-minded, industrious country was traveling. Now, from this book, Trademarks of the 20s and 30s by Eric Baker and Tyler Blick, we are going to talk about some of the different kinds of marks that they show. Now, in 1928, Walter E. Disney trademarked this name for copies of Mickey Mouse movies. Now, this rodent here, his mark is called a stylized word mark for a word that is written in a particular way. And then in the same year, 1928, Radio Corporation of America designed its initials, RCA, in a very stylized way. They added a lightning bolt for emphasis, and they had a circle. And this kind of a mark is called a design and stylized mark because of those design elements. In 1931, the company we now know simply as IBM used all of their name in order to form a sphere, or the Earth. And the Earth is a very popular kind of symbol for a trademark. We're supposed to read this International Business Machines. And at the time, their name was actually Tabulating Machine Company, and this mark was used for card punching and card sorting machines, which are actually the forerunners of the machines we call computers. Now, this kind of mark is also actually a stylized mark. Now, the Earth is shown in this mark as well. This is by Sherwin-Williams Paint, and you see that their paint can and the paint covering the Earth. This was done in 1935, but it's still a familiar mark to us that's used today. Now, sometimes the images of a mark, you see the image there, are more memorable than the mark itself. In 1927, if you needed an artificial limb, you might have been attracted to this image of a little girl, and she's holding a leg, an artificial limb, and says, "My papa's leg." On the other hand, I'm not too sure you'd be interested in using this tooth exercise gum. And then you'd have to think about the image of having this very muscular tooth inside your mouth. He's got shoes and he's lifting weights. I'm not sure that mark works. But sometimes an image alone without words is a memorable mark. Now, this lascivious man's face was trademarked in 1935 by Esquire Incorporated for its magazine and for a column. And I want you to note the heart-shaped pupils. You see that? And I'm sure that that's because of this man's love for the excellent articles that were appearing in Esquire. Had nothing whatever to do with the drawings of beautiful women in there.
I'm sure.
You know, I remember when those pictures were considered racy, but, you know, today they are just tame.
Are trademarks always so fancy?
No, not really. Today, especially, they're using simpler images. You can think of the Nike swoop. That simple image has become so associated with sporting goods that they don't even have to show the shoes anymore for you. When you see that swoop, you know it's Nike's sporting goods. The important thing is that it's attached to a goods or service. You can have a very plain mark with absolutely no design at all, just plain word mark, and this should be, yes, this is our Microsoft mark, and as you can see, it's absolutely plain. There's no design on it whatsoever. But what's important is that the word itself has to be fanciful. It can't be too descriptive, because if it's descriptive, then it's not going to be protectable. For example, here, lead pencil. Now, if you used lead pencil as a mark to refer to a pencil, that obviously is not distinctive. It's not going to be trademarked. It would be unfair to give you exclusive use of the words lead pencil for this kind of a product. And also, it would be very hard to protect that mark. I mean, how are you going to stop other people from using lead pencil to describe this product? So the mark is also called a weak mark. And Glenn, you know something about that, I think.
Yes, a few years ago I owned an upscale candy store known as the Chocolate Box, and I attempted to register that as a trademark.
And were you successful?
Well, I was successful only if I submitted it with a certain design, which made it then exclusive.
Right. And then you had, I think, 3 stores all called the Chocolate Box?
I had 3 stores in Massachusetts, and I was successful in defending that mark within Massachusetts, even though I had it registered federally across interstate lines and everything. It was much more difficult to protect it across the country.
Now, with other stores that call themselves the Chocolate Box, did you let them know that you were the owner of the mark?
Yes, we would notify them in writing or call them by telephone. As I say, in Massachusetts we defended other people from using that name, but it was more difficult in other states, and it would have been more expensive to take them to court.
Now, the Chocolate Box is a cute name for a candy store, but it's suggestive. It's suggestive of candy stores, and that's one of the things that makes it harder to protect. A very strong mark is this mark. This is Kodak. Now, Kodak is a strong mark because when it was invented, it was just completely made up. There was absolutely no word called Kodak. It didn't mean anything at all. But when George Eastman put it on his cameras and heavily advertised Kodak cameras, it became strong. It's now, I think, probably one of the strongest marks in the world.
Is a trademark always a word or a design?
No, not necessarily. There are marks that are called sensory marks. For example, you can even trademark certain musical notes. Now, when you hear a certain 3 notes, you know that the television program that you're watching is a program of
NBC.
So trademarks can be words, designs, sounds. Can they also be colors?
Yes, they can be colors. That's something that the United States Supreme Court has just decided recently. There is a color pink that is actually trademarked for insulation material, because pink is not functional for insulation material. It doesn't do anything. It's just fanciful. And so when the Owens Corning Company applied it to its insulation material and also had this very big advertising campaign using the Pink Panther, pink and insulation material became associated under the Owens Corning brand, and now they have the exclusive right to color their insulation material pink, and no one else can use it. And there are some other products, the manufacturers of which have succeeded in trademarking the color.
So why is it so important to know the source of what you're dealing with, that we have a whole body of laws protecting trademarks?
Well, that's in order to protect consumers, actually. It's very important that we know what the source is of the product that we're dealing with, because if we're going to be informed consumers, we're going to know something about the quality of it. Now, I'm awfully glad that you asked us about that, Suzanne, because if you hadn't asked us, we really wouldn't be able to get on with the rest of our program. Glenn Doyle and Carolyn Najarian are going to help us answer the question of why it's important to know the source through trademarks. Shakespeare, as he often did, posed the question best. You know, one of his characters said, "What's in a name?" But I'll bet you didn't know that the famous balcony scene from Romeo and Juliet is really about trademarks. Listen.
Romeo, Romeo, wherefore art thou Romeo? Deny thy father and refuse thy name.
Juliet wants Romeo to give up his name, because by that name he's identified as a member of the Montague family, and Juliet's family, the Capulets, are feuding with the Montagues. She can't date Romeo because his name tells her parents that he is a member of the hated Montague family.
'Tis but thy name that is my enemy. What's in a name? That which we call a rose would otherwise smell as sweet. So Romeo would, were he not Romeo called, retain that dear perfection which he owns without that title. Romeo, doff thy name, and for that which is no part of thee, take all myself.
Okay, darling, just call me Bob.
Juliet may believe that if Romeo were called Bob, then, number one, she can date him without her family knowing his origins, and two, he'd still be perfect for her. Now, maybe that's true about people, and we do try to teach our children that it is true, but I'm not sure it's true about products and services. I mean, really, would a rose smell as sweet if it was called a stinkweed? I'm not sure about that. Certainly, advertisers think there is much in a name. For example, the Coca-Cola Company did not think that a soft drink by any other name would taste as sweet. Has this ever happened to you?
I'll have a cheeseburger and a Coke, please.
Pepsi okay?
Whatever.
The Coca-Cola Company was concerned that restaurants that did not actually have Coke in stock would serve Coke to any customer asking, would serve whatever cola they had to any customer that was asking for a Coke. So they'd serve them Pepsi Cola or Friendly's Cola or whatever. Now, that is not a good idea whenever a customer asks for a Coke. Coca-Cola was annoyed.
Why would they even care, though? It just shows how famous their brand is.
Well, there were two reasons. Of course, if the restaurant had to stock enough Coca-Cola to give it to everybody who asked for Coke, then, of course, Coke would make more money. But the second reason is that if you could just serve any old cola whenever anybody asked for Coke, then pretty soon that very valuable trademark would be lost. Any cola drink would be called a Coke, and it would be legal. So probably more to protect that than for any other reason, the Coca-Cola Company actually brought suit against restaurants to make them identify and let the company know that if the customer asked for Coke, they were going to be served something else. But this is how they did it.
I'll have a cheeseburger and a Coke, please.
Pepsi okay?
Okay, so now I see why a company cares if a trademark is misused. But why should the government care? Why should the law protect a company's trademarks?
Well, remember I said that it was important that consumers not be confused. We have a right to know what the origin of the product is, so we know what quality it is, and also it's important to know the source in case there's a defect in the product.
Excuse me, I bought this famous brand item from you a few days ago, and it caused an accident which caused me serious physical harm. Now, I want you to pay 10 times its value, otherwise I'm going to call my lawyer.
Well, I'm sorry for your injuries, but this is not our famous brand item. It's a cheap imitation that's been dressed up to look like ours and has been given a similar name. Not only will we not pay you anything, but we will have our lawyers call the makers of this item you're holding and sue them for trademark infringement.
So, trademark laws encourage a provider of goods or services to educate folks about the quality of their stuff by allowing exclusive use of the mark to identify those goods and services. Now, at the same time, trademark laws prevent consumers from being misled as to the source of the goods or the services they are buying or using.
How can the owner of a trademark obtain this protection you're talking about?
Well, first of all, they can obtain common law rights by just using the mark. For example, if you had a store and you called that store a certain name and that name was associated with the services you provide in that store, well, then no one else in your town can use that name whether you register it or not. And even in some instances, if your store is well enough known and associated with you, even if a federally registered trademark owner came in and said, you have to stop using that name because we have a federal trademark, you could actually hold on to that name. That's what happened to Mrs. Rexall.
As in Rexall drugstores, the famous drugstore chain?
Yes, except that Mrs. Rexall owned and ran just one drugstore in her town. But when the famous drugstore chain came in and said, you have to stop using your own name, Mrs. Rexall, because we have a federal registration on it, a court sided with her and said, no, she could continue to use her name on her store in her town. Of course, she could not expand the operation and go ahead and open more Rexall's stores.
So if Mrs. Rexall had not been there before, she couldn't just open up a drugstore and call it Rexall's, even though that was her own name.
That's right. There's really no special right to use your own name. Well, think about that, because let's say your name is McDonald. You wouldn't have the right to open a chain of, or even one, hamburger restaurant, because what you would be doing is trading on all the goodwill and all the advertising that the national chain, McDonald's, has invested in its name.
But what about famous people? Say, for example, I made football products, and I named them Drew Bledsoe Footballs, and I registered the name Drew Bledsoe. Would that mean then that Drew Bledsoe couldn't use his own name on products because I had already registered it?
Well, that's not supposed to happen. When the trademark is examined to see if it's registrable, if there is a name of a person involved, whether they're famous or not, the trademark examiner is supposed to make the applicant show that there is permission from that person to use the name.
Well, what exactly is registration of a trademark?
Well, you can register your trademark in your own state just by going down to the Secretary of State's office, getting an application, paying a fee if no one else is using the mark, and if you don't have a confusingly similar mark at use in your state. Now, you can also register the mark on the principal or supplemental register of the United States, but you can only do that if you use the mark in interstate commerce. Now remember that we always go to the Constitution for our basic principles about law, and for trademarks it says that Congress only has the right to regulate commerce with foreign nations and among the several states and with the Indian tribes. So that means that the United States Department of Commerce can only issue a mark and protect your right to use a name nationally if you're using it across state lines. Now, there are a lot of steps you have to go through to register a federal trademark. There's also an application and a fee. But the most important thing about it is that if you achieve a federal registration, you have the right to use the circled R. But you can only use it if registration has been achieved. And using the circled R without a federal registration is just not allowed.
So now, once there is a federal registration, then the owner of the trademark is the only one who can use the mark for the same or similar goods that are covered.
Right, that's right.
For how long can someone keep that exclusive right to use a trademark?
Well, you can keep a trademark way beyond the registration period. The registration period is only 10 years, but if you followed all the rules and you keep it current and you keep paying the fees to renew it, you can hold it forever. So a trademark is a very valuable piece of property, and it can be transferred. But you have to use the trademark properly, or it can be lost.
What do you mean lost? Well, let's say, for example, again, that I have a trademark or a service mark, and my mark is taken by an infringer, but I choose not to sue. Does that mean I can lose my mark that way?
That's one way you can lose a mark. But there's a much more common way. Here's a riddle. What do these words have in common? Elevator, escalator, aspirin, cellophane, and creosote.
Don't tell me they were all trademarks.
They were all registered trademarks once upon a time, and they have all become common, ordinary English language words because they were not used properly and their owners did not take steps to make sure that they were used properly. Now you can think of some current trademarks that are in trouble because they are being used as though they were words in the English language. Here are examples of a couple of them because people are using them as generic terms.
Can you Xerox this document for me, please? I'll need 10 copies by 10:10 today.
Now, as a recent ad by the makers of Xerox copy machines says, when you use their trademark as a verb,
can you Xerox this document for me, please?
then they need an aspirin. Now, what would the makers of Xerox copiers like us to say?
Can you xerographically reproduce this document for me, please, on our Xerox brand copier? I need it by 10:10, but it's taken me so long to request this that the deadline's passed.
Oh, I'm sorry, I can't. I've cut my finger. Can you get me a Band-Aid brand adhesive bandage, please?
Now, since it's unlikely that any of us are going to start talking like this anytime real soon, owners of popular trademarks will have to just keep up their educational ad campaigns to make sure that they don't lose their very valuable protection and have these words just become a part of the English language. Now, remember that that's important to us too, because protection of trademarks is only allowed because it's deemed to be a protection of us, the user of the trademarked product or service.
Well, Sidel, is trademark protection available outside the United States?
Yes, trademarks can be registered all over the world. And except for very few internationally known marks, you do have to register your trademark in each country in order to have the exclusive right to use those marks right there.
And what about the internet?
Well, registration of domain names had been a problem. People were actually stealing trademarks of other companies and just thinking that it was cute to use their own domain name address as some famous trademark. Because a domain name is actually an address on the internet, it is not necessarily associated with products or services, then they got away with that for a little while. But through litigation and registration process, now there are steps that are being taken to prevent that kind of trademark piracy.
Sidel, to some people, trademark laws may sound complicated. Does one always need a lawyer to handle this?
No. If you have a state registration that you want to achieve, you can just go down and ask the Secretary of, in our case, Secretary of the Commonwealth or the Secretary of your own state what to do to register your mark. It's usually not very complicated at all. If you want a federal trademark, then you can get this booklet from the federal government, Basic Facts About Registering a Trademark, and you just write to the Department of Commerce and ask them for it. But for the more complicated aspects of trademark law, for example, is the mark too suggestive? Will I be able to protect it? For some of those things, is it too close to a nationally known mark? Then you may need a lawyer, but not right off the bat, not necessarily. Well, I hope that folks today found our program entertaining as well as educational. And I want to take this opportunity to thank Glenn Doyle, Carolyn Najarian, Suzanne Koenig for assisting us. And if you have questions about coming up against the law, we'd like you to write to us and give us your suggestions as to what we should cover on our programs. We can be reached at Continental Cablevision, 80 Skillings Road in Winchester, Massachusetts, 01890. or on the telephone at 721-2050. Thank you. Goodbye for now.